So good morning everyone and welcome to yet another edition of SMS. And जहाँ पे हम लोग सब मिलते हैं अभी जैसे हम लोग डिस्कस कर रहे थे just like students who are preparing for the exam preparation नहीं हुआ but एक जन दूसरे को फोन करते हैं. So GSTAT filing में we are also struggling, we are also facing challenges. Now after GSTAT filing we have gone to the stage of hearing. So today we'll deliberate on some of the issues which are being reported as defects and also about how we are going to approach the hearing part. So over to Arpit ji. I think for some of the practical aspects he is going to share with us regarding the starting of one of the benches in Jodhpur.
And
Arpit ji, over to you.
whatever is the experience from the other benches, the participants
Yeah.
can come and share, because then it would be having a wholesome view. So when we met
Yes.
him, met the assistant registrar for Jodhpur bench yesterday, we submitted him a representation right from Rule 19 to Rule 56. And interestingly said, sir, I have read only up to 24 because I am only up to admission now.
But
Excellent, excellent.
syllabus में कौन सा मतलब exam में कौन सा आएगा वही पढ़ेंगे उसके
So even if you are referring to subsequent rules, I have not gone through. So whatever you say, I will accept it after that.
ये सही है.
Great,
Yes.
great.
But Arpit ji, before you proceed, I want to give one
हाँ,
disclaimer.
हाँ.
मेरे भी GSTAT filing अभी बाकी है. It is only the party shirt that I am wearing. I am not doing any party. चलिए, Arpit ji,
हाँ,
over to you. Yes.
हाँ. So the first thing which we confirmed is what would be the date of receipt of the appeal, whether it would be on the date when he is admitting or date on which I am uploading. So he clearly admitted that the date on which you have uploaded the appeal would be treated as the date of filing of the appeal. So that was pretty clear. But since we started from the scratch, so therefore we asked him that what would be the date of appeal. So he said date of filing of the appeal would be the final appeal. Next, we stated that as per Rule 24, first he has to scrutinize the appeal, then the defects have to be communicated. 7 days time period would be given. Thereafter, if he is satisfied, he would accept. Otherwise, he would give a PH. And even after PH, if he is not satisfied, he would put the matter before the bench. Or if he is satisfied, he can drop it. Or if nothing has been done, again the matter would be referred to the bench. So the first hearing which has been placed in Jodhpur bench is regarding the defect. So we asked him that, sir, whether the AR did not come and completed the defect. So he said that AR is also one of our association members only. AR is
अच्छा.
also one of our association members. So he said that, sir, there is a communication error which is taking place on the GSTAT portal, wherein if we are sending the defects, they are not being communicated. And even the initial defect which was communicated, initial PH which was communicated by the registrar, nothing was communicated. And even the defect which is now being put before the bench, they have been communicated by phone and they have not yet received the link for the hearing. So then he communicated the NIC, and the NIC, there's a particular issue with the GSTAT Jodhpur bench. So since it is an issue with the GSTAT Jodhpur bench, there might be similar issues which might take place at the other benches also. So we asked him, sir, whenever you are issuing a defect in the initial phase, let the AR be communicated because you have the phone number of the AR or the appellant, and then only the defect hearing or the PH and the registrar code should take place, because ultimately the defect matter should not go before the bench, because initially the bench would think that what is happening, that all these appeals of this particular AR is coming before for resolving a defect before the bench, so it would give an inappropriate impression to the bench. We asked them that when the appeal is being filed, whether a communication is being made to the respondent or to the respondent. So he was not aware, and in some cases we are receiving, and in some cases we are not receiving the. So this was all about 24, which we asked, and attaching to that, we also asked, sir, when you are seeing the defects, whether you what are the relevant documents which you are seeing. So he said that only the relevant document as per the presidential order. So then we asked कि post 31st December we would be uploading all the RUDs because the relaxation would be gone. So he said that, sir, even if you upload all the RUDs, I would not be in a position to see all the RUDs because ultimately I have to admit the appeal. If I start seeing all the RUDs and matching it with the appeal, then it would be a cumbersome task and we would not be able to analyze and see one appeal per day. Ultimately, the pressure is on us to admit the appeals or issue the defect notice. So what he said that even if the RUDs are being uploaded, he is not in a position to check all the RUDs and whatever we have mentioned, it is matching with whatever you have attached. And what we said is once the appeal is admitted, how the balance RUDs, supposedly I have submitted the appeal and I have relied upon 20 annexures. But while filing the appeal, I have only uploaded the mandatory annexures, but not uploaded the balance annexures. So what he said that once the appeal is admitted, there would be an link to upload additional documents, and those documents can be uploaded before the hearing. And then the bench would be able to see those documents, and then they will take it on board. So this was what we asked him for the balance documents other than the mandatory documents which would be uploaded, and this was the communication which we received. If any member who have interacted with their local ARs, assistant registrar or registrar, and have any feedback on this part, they can, because ultimately what I see from discussion yesterday, that individual benches are going as per their own perception of the rules and the procedure. It is not that a common procedure is being followed across the board. So here the AR might be having a different interpretation, and even at Jaipur, there's a different interpretation. I also asked regarding the translated document. He said that Vice President of Rajasthan bench clearly said that there is no requirement for translation of documents from Hindi to English because all the members at Jodhpur and Jaipur bench are conversant with Hindi. But here the members who are at Jodhpur bench clearly communicated to the AR that whatever documents are being received, they have to be translated, and we would not be entertaining any appeals which are not translated into English. So each bench is having their own view, even though all the members are conversant with Hindi, but still they want translation in English. And going beyond what the Vice President Raisan of GSTAT has said in an open forum and clearly communicated to all the ARs. So this was the discussion about Rule 24 which we had. If anyone has to add or has experience with discussion or communication which they have made, they can also share it.
Arpit sir, in Bangalore, they are actually calling to the AR also by way of phone, and they are saying that we have already issued a defect, so please look into those cases. So in few cases, they are calling personally also in Bangalore.
We have also asked him to do that because the
Yeah, so they
communication is not
started
coming
in
properly.
they have started in Bangalore. So that is what they are doing. Rather, they are reminding them that we have already issued and correct the defect or meet personally as such.
And one thing which he said that there is a clear instruction that no appeal should be rejected on the basis of any defect. Ultimately.
Yeah.
Harpreet ji, वो लेकिन हो रहा है because even if there is a defect, as you said, as per the rules, they are going those 3 steps. First, they are sending the defect. आप rectify कर दे रहे हो तो ठीक है. Then they are having a hearing with the registrar. वो नहीं कर रहे हो. Then the third step is to have a hearing before the bench. So they are following all those things. अभी तक हमारे यहाँ पे भी कोई defect के लिए कोई rejection ऐसा कोई नहीं हुआ. Any other bench having any other experience of any defect?
I would, yes, sir. I would, yesterday in the Raipur bench has also commenced the hearing. I would, and they have issued the cause list for 4-5 days. And what we have noticed is that, first of all, that the email which is supposed to come to the authorized representatives, they are not coming properly. They are not coming properly, as if like if
Ravindra, you have mute हो गए.
so in one of the case it has come, and in many cases it has not come. So it is selectively coming, and and it is not coming to all the ARs. It is only coming to 1 or 2 or 3. So it is a kind of a glitch. And for this, I think we should be geared up to check periodically our cause list every Friday or every week. We have to check. Otherwise, there is a possibility that we may miss it. That this issue we
नहीं, Raman,
pointed out yesterday also, and they agreed, yes, this is the problem, it is happening. Yeah.
but रमन जी आपके वो टैक्स पेयर के पास नहीं गया क्या मेल?
So taxpayer के पास भी sir selectively आ रहा है. I mean, if
अच्छा, I think it's initial glitch.
yes,
Well,
initial.
for us,
हाँ,
in Kolkata, taxpayers are getting it, ARs are getting it randomly. कभी मिल रहा है, कभी नहीं मिल
randomly.
रहा है.
Yes, yes.
But for taxpayer, every taxpayer is getting it now with the WebEx
Yes.
link and all. मतलब अगर आप virtually
Yes.
join करना चाहते हो तो WebEx link, so that
Right.
is there. वो हो रहा है. And
Another
regarding the cause list,
yeah.
and regarding the cause list, you are lucky कि आपको 5 दिन का मिल रहा है.
हाँ.
Calcutta is still following the system of having daily cause list only. तो हम लोग को 6:30 बजे पता चल रहा है कि next day cause list में क्या क्या है.
Right.
If it's a new hearing, अगर मेरा
So
continuation है, मतलब
we
मेरा
requested them.
last week हुआ
We
तो अलग बात
requested
है.
them in very initial
हाँ.
phase only, Arup sir, that every Friday they are supposed to issue Friday evening, so that people can get prepared for the next week completely. So they are
That we
doing
have also
this.
requested to
Yeah.
we have requested our vice president sir also.
Yes.
But till now that has not been made effective. So I think it's one good initiative in your bench.
Another
In the right bench.
another point which I would like to raise before all of you to just discuss that whatever hearing which has been coming up, they are calling it for the sake of acceptance of an appeal. Admission, yeah, admission of an appeal. So point. My point is, why is this hearing required? First of all, because when there is no defect, when there is nothing, it is not a civil defect. It is an appellate remedy which I am exercising. Why is this? Why is this admission required in this particular case? Uh, is there any necessity in the rules or law?
Yes. Rules I have to check, but Ramandeep ji, this is a protocol that is taken from the High Court also. In High Court also we have an admission hearing. And in our admission hearing, I'll tell you what is happening in our bench in Kolkata. In admission hearing, if only in case you are filing the appeal and the department objects that इसका maintainability नहीं है, इसका place of business का issue है, my lord, so it has to go to the principal bench. यहाँ पे maintainability नहीं है. So that is not there. Then in case of say pre-deposit not filed, maybe the nodal officer has missed it. Maybe the registrar has also missed. जैसे अपने यहाँ पे एक मैटर में क्या हुआ है, रिफंड का मैटर था, you got the refund, they filed appeal before the first appellate authority. First appellate authority rejected the refund, but they have not created any demand. तो क्या हुआ, टैक्स पेयर ने क्या किया, कोई प्री डिपॉजिट फाइल नहीं किया, पे नहीं किया, दे हैव फाइल्ड द थिंग, एंड क्योंकि कुछ डिमांड में दिख रहा था, तो somehow nodal officer also did not check.
Arup sir, majority of the point.
So that means
Majority of the point that they can cover up in the defect part itself. As far as maintainability is concerned, you are right. They can very much covered in the proceeding itself, and they can very much plead in the. As far as I have seen the proceeding of ITET and SESTET, this was never a part where you have to plead first for the admission and then the detailed proceedings take up. I discussed with the ITET people also, and I've attended some of them also. So I find strange that.
But यहाँ पे they are giving selectively matters on admission. Not all matters, but selectively they are putting. That is something we have to see, explore why they are giving some of the matters. But in the matters where they are giving in admission, they are basically seeing whether the appeal is at all maintainable. Then about the NLP वाला amount, वो defect में शायद पकड़ा नहीं गया, तो उसके बारे में admission के बारे में से कि amount below the threshold है, फिर भी department appeal में आ गया. Where is the point of interpretation of law?
Yes. We in fact what we observed that they were asking yesterday in one of the case that does this have a question of law, so it will be put it in division bench or single bench. So they were asking properly, and what was the law they were discussing, and that is why they are mainly doing this. I think I see one of the reason of this also. And
you are right, sir. I think I have read somewhere that if a appeal has to go to single bench, again DB will decide what has to be going to single bench or what is to go to retain with DB. I think that may be a reason, and I think most of the appeals are for single benches only. Most of the appeal, majority of the appeals, I think. So I think they will be doing it like that.
Yes, sir. So another strange and very view which we I mean heard yesterday from one of the member that somebody, I mean, this is not the result of the member's own thinking, but somebody from our fraternity asked a question during one of the interaction program that, "Okay, sir, for a adjournment application, do we need to file fees also?" Then members said ki yes, you are required to file an appeal fees for that if you are filing an application for adjournment. So
Ramandeep ji,
तूने clarify कर दिया ना? This
this issue is
clarified.
already taken up,
yes,
and at present, if any application required to file, yet a fee has to be deposited. But the amendment which has been proposed, whenever it is
Yeah.
done, then it would be not required.
yes. So we said ki sir, already this has been taken up, and so he was like ki nahi, you have to pay every time. Yes.
I have to use that GSTAT is being run in a Supreme Court mode. They are not
Correct.
treating themselves as in Supreme Court.
And
नहीं अर्पित जी हम लोग अमेंडमेंट के लिए एडजॉर्नमेंट के लिए पहले तो डालेंगे ही क्यों वहां पे अटेंड करते हैं करके एडजॉर्नमेंट ले लेते हैं बात खत्म एप्लीकेशन
नहीं मैं वही बोल रहा हूँ कि इसको क्या है, सुप्रीम कोर्ट से नीचे चल ही नहीं रहे, और जो टैक्स मैटर इन्वॉल्व वाला है,
हाँ
क्वेश्चन ऑफ इंटरप्रिटेशन ऑफ लॉ, जो उन्होंने
हाँ,
बोला
हाँ।
है कि भाई वो प्रिंसिपल बेंच को जाएगा, ये आपने उठाया क्योंकि मेरा बहुत स्ट्रांग व्यू है और मैं चाह भी रहा था आज इस पे डिस्कस करने के लिए.
हाँ.
See, question involving interpretation of tax, they are now referring it to principal bench, and it is coming from the notification. First thing,
नहीं अर्पित जी थोड़ा इसका बैकग्राउंड बता दिए फॉर द इंटरेस्ट ऑफ द मेंबर्स एवरीबॉडी.
हाँ नहीं देखिए एक मैं वही बोल रहा हूँ, there was a notification issued wherein they said that some of the matters would be lying before the principal bench, and one issue was where the interpretation of statute was a matter. Then they would be going to the principal bench. That amendment was, that notification was notified in 12th of September. Now the first matter which was taken to the principal bench was admission of appeal before the appeal authority beyond 4 months. So that is something issue which is pan India, on which no ascertainment of fact of the matter is required. Only thing which is required is date of communication, date of filing, and whether the appeal authority has the power to condone the delay. Other than that, if there are 10 issues on merit, they would not be going into the 10 issues. So that first matter was taken up. And as we discussed in the last meeting, that it is a gone case, that I would not say gone case, but it is something which is being settled by Supreme Court for other benches, and said in open house by the President GSTAT also, that they don't have the power to condone neither the tribunal nor the appeal authority beyond 4 months or 6 months, as the case may be. But now what is the trend which is going on is, recently, yesterday, I only read that two matters are again also referred to the principal bench. One is regarding the taxation of royalty, and second is regarding applicability of Section 73 in case of amalgamated company. Now, today I have read another matter which will be going to the principal bench is ITC on the telecom towers. Now, I have many apprehensions and many objections to this. First thing is, question of law. What is question of law? See, this question of law thing is before the Supreme Court. And when the Supreme Court takes the question of law, it is based upon what has been given by the High Court. So High Court drafts a question of law and then it goes before the Supreme Court, and then the Supreme Court decides. Supreme Court is not a fact-finding authority, so he would not be. Supreme Court does not go into the fact. They only decide the question of law, and which is framed by the High Court, and which has been given ample consideration by the High Court, that whether this matter needs to go before the Supreme Court, and it is a constitutional remedy which is there. Tribunal is not Supreme Court; it is the last fact-finding authority. And if they are treating themselves that they would decide the question of law, so in that way, on a lighter note, on a casual thinking, there might be about 2,000 appeals in Rajasthan on royalty issue, which would be traveling to the principal bench. Leave aside what would be happening from the other, what would be going from the other states. Now, in this royalty matter, supposedly my order has 10 issues, out of which one issue is pertaining to royalty. Whether the tribunal would be hearing all those 10 matters. So what would happen in that case? That all those 10 matters travel to principal bench. Now the principal bench in all those 2000 cases would be appointing an amicus query who would be supporting the bench. So that means not all the counsels would be heard, only certain few other than the amicus would be heard, and the matter would be decided. Now, what happens to the rest of the 9 matters? That would not be deliberated or argued by the amicus. That has to be argued by the counsel. So, if all those 9 matters are to be separately argued by the counsel before the principal bench, that means we have taken all the matters which involve question of law to the principal bench, because even a 3B2 involves a question of law. So all the matters pertaining to 3B2 would also travel to the principal bench. And what happens is, first, I would not be getting the opportunity to argue on the principal matter. Secondly, if they hear me on the rest of the 9 matters, they would be hearing all the appeals. So all the appeals would be concentrated to principal bench. Thirdly, whatever order is there, that appeal would lie out to the Supreme Court. Now, what has happened is my opportunity to file an appeal before the High Court is also gone, because the matter has been taken up by the principal bench, treating it as a question of law. There was another issue which was discussed, that the principal bench would only discuss the question of law and rest of the 9 matters would be taken up by the state benches. This was because I had a discussion yesterday with many prominent organizations, Office Bureau on this issue, because we are taking it very seriously that this cannot be the mode of working, because by this mode, the state benches would be left with no work. So the second argument which came is that the question of law would be decided by the principal bench and rest of the 9 issues would be taken up by the state bench. So the decision on the question of law will come to the state bench, and state bench would take it and incorporate it into the order and pass the order. Now the question comes that when my appeal itself has been transferred to the principal bench, and principal bench only takes and decides one issue, and the state bench incorporates that same in their order. So this is not an order which is being given in some other case and has been relied upon by the bench. This is an order given in my case and incorporated in the order by the bench. And for the rest of the 9 orders, they would be giving their own order. So that means in their order, if this approach is followed, they would say that principal bench in your case has held that this royalty is taxable in GST, and rest of the 9 issues, we say that this is the treatment. Now, even if it is part of the state bench order, it is a decision by the principal bench. So does that mean for that one part, I would be going to the Supreme Court, and for the rest of the 9 issues, I would be going to the High Court. So can an appeal be divided into 2 parts? First, for one matter before the Supreme Court, and for the rest of the 9 matters before the High Court. So what is happening, and when I tried to search regarding the notification which was issued for involving dispute of taxation interpretation of law, I went through the agenda of the GST Council meeting, although it is not in public, but have the reference to the same. In that case, this question of law issue was not part of the notification, initial notification, which was part of the agenda. I don't know about the minutes because they have not been released. What is there, whether the GST Council stated and incorporated the question of laws, even though it was not part of the agenda. I am highly doubtful, but this was not part of the agenda also. Not aware of the minutes part. So this entire thing of question of law is like taking out the powers of the state benches and concentrating all the matters to the principal bench, and wherein certain 2 to 3 persons would be appointed as an amicus curiae, and then all of us would be standing here looking to the principal bench, attending the hearing and not able to say anything about what we have to argue and what was part of our grounds of appeal. So in my opinion, this entire matter of appeals being referred to the principal bench on account of question of law needs to be taken up very seriously by the respective associations. See, there are 24 benches. They are not here to decide whether 2 plus 2 is 5 or not. They are here to decide what is my matter on merits, whether it involves question of law or not, because tribunal is the last fact-finding authority. They cannot treat themselves as a Supreme Court and decide that we are the whole soul in the entire GSTAT and the president would be deciding everything. So what I have discussed with all the associations, we are in the process of sending a joint representation with the prominent and other organization whom we are able to get in touch on a joint basis, signed commonly by all the associations on a single representation, so that the matter is taken up and ultimately it is resolved, because this is not how GSTAT was supposed to work. So this is my opinion. I would seek opinion from other members also on this issue.
अर्पित जी आप बोलना चाहते हैं कि सबका साथ सबका विकास, राइट?
हाँ,
सब एक साथ जाएंगे।
अब तो करना ही पड़ेगा,
together.
नहीं तो क्या है अरूप जी, आप और हम बैठे रह जाएंगे, उधर 2-4 चार्टेड अकाउंटेंट या लॉयर्स है ना, वो काम करते रह जाएंगे।
Exactly, right. I agree with your views, but like any other member has any counter view or?
Can I say something?
Yes, please, sir, please.
RPG, you are right. This cannot happen. And there are a couple of members which has came to my knowledge. Couple of members who are doing this. And this is the role of president. Unfortunately, the president is now also considering that he is sitting as a jurisdictional court, as a constitutional court. So that is the difficulty. So I suggested this yesterday when you dropped the message, no, in a group. So thereafter, I had a word with a couple of members also, because today there is an opening at Surat bench also. So I had a discussion with them also and the president also. So he was also of the view that yes, there can be a representation, and we'll consider that representation. But I personally believe that making a representation to the president may not help us. So we'll have to go to the council also, because unfortunately, ये मनमर्जी type चल रहा है.
Yes.
And secondly, what is the purpose of tribunal and DB? If every question of law is going to travel to principal bench, then there is no point in having a division bench.
Yes.
Let it be a single bench, only the facts will be decided by them, and if any question of law is there, that has to travel to the principal bench. And even I have raised one query, and in the verge of making a representation also, that this is a very settled question, that whether the condonation can be further there or not, specifically by the statutory authorities. And if they consider this as a principal bench, obviously they are going to reject it. All the matters will be dismissed. So department, this council is working on an amnesty scheme. So the entire efforts of bringing an amnesty scheme, the purpose will get defeated the moment the appeals are getting dismissed. So we are also on the verge of making a representation that I would suppose that we should make jointly. That you hold back these decisions till the amnesty is ruled out or till the amnesty is announced. Otherwise, once it is announced, once they dismiss it before the announcement, then obviously everybody will have to rush to the High Court. High Court को तो मजा आ जाएगा, disposal मिल जाएगा.
अविनाश जी, Supreme Court, principal bench.
हाँ, correct. Principal bench have to direct to Supreme Court. Or Supreme Court, they have already settled it. So I don't understand what is the purpose of doing it, because they want to bring every taxpayer on their knees, or I don't understand. तो ये represent करने की जरूरत है. We actually I raised an objection also, and you are right in saying amicus query भी जो ये appoint कर रहे हैं, अपनी इच्छा से कर रहे हैं. किसी को भी, they do not have that standing in the judicial field. Judiciary में उनका कोई ऐसा standing नहीं है कि वो. So why those persons should be entertained? So this also I raised with president. So he said कि नहीं हम सबको सुनेंगे. If you also have a matter which is transferring, which is being transferred here, then we'll hear you out. Then I said, what is the purpose of amicus query then? वो आपको क्या बताएगा? See, with something which is already settled, he is not going to say anything on that. So, and plus you also need to consider that the question which you are taking up, and at such a large scale, does that question gives you, or that answer is within your power?
Yes, true.
आप वो दे भी सकते हैं कि आंसर. अगर आप नहीं दे सकते, actually I had a one-to-one discussion with the Surat member also, judicial member, because he was a lawyer.
So he understood everything and he said कि sir देखो हम तो ये करेंगे कि we'll hold it up. We are not going to decide, but let the principal bench decide it. And secondly, once they decide, we will be helpless because president has given a mandate कि जितने भी आपके ऐसे matters हैं registrar को, those matters should be referred to the principal bench. So you are right. We have to take it as fast as possible, and strong representation has to be there. Otherwise, तो ये मनमर्जी चलेगी. And see, majority of the members are new. They have never been to this judiciary. They have always been to the quasi judicial authority forum. तो वो हमेशा वो डिपार्टमेंट की तरह से रहे या फिर हमारे जैसे लोग रहे जो प्रैक्टिस में थे. So वो एक्साइटमेंट एक रहता है. तो एक्साइटमेंट में मुझे ऐसा लगता है कि कोई गलती नहीं हो जाएगी. अब I'll share one thing. What has happened day before yesterday? I met one of the members. He said कि अविनाश, what we are observing is कि 15-20 issues हैं. मोटा मोटी 15-20 issues हैं GST में. So we'll one by one we'll decide all those 20-25 issues, and then we'll follow. मैंने कहा sir, how you can do that? Because every matter has a different fact.
Different fact.
So you cannot like simply follow whatever you have decided. You will have to consider the facts. And on the contrary, if let's say my matter does not comes up, and there is some other young lawyer whose matters comes up, and he is unable to argue, and you will decide on that matter, then I am also gone. So वो situation so you should avoid as a tribunal at least for the initial 6 months.
Yes, true.
आप ऐसे matters को आप साथ में रख लीजिए, आप उसको bunch कर दीजिए, and then you decide it. In spite of being in hurry and deciding the matters, where is the question of disposal here? अभी तो disposal है ही नहीं, अभी तो filing चल रहा है.
अभी तो फाइलिंग ही चल रही है.
आपको खुद को पता नहीं, आप खुद बोलते थे 4.5 lakhs and there is 60,000 only. So he was. So things are unsettled, so don't try to settle it. That was my request to him.
और इतनी जल्दी सेटल करने की कोशिश करो मत. ये तो 10 साल के इश्यूज हैं. Take a deep breath and then start.
Exactly. So they are saying we are already ready with the orders in couple of the cases, couple of the issues. So I requested don't do that, sir. Otherwise जो अच्छी representation या सही question आप decide कर पाओगे, अच्छा judgment author कर पाओगे, that will go.
So अविनाश इसलिए शायद उन लोगों ने कैटेगरी ऑफ द केस मांगा था. कैटेगरी के हिसाब से हम लोग बात कर.
मे बी क्योंकि ये बहुत सीरियसली लेने की जरूरत तो है. अर्पित जी, मैंने कल भी बोला था, अभी भी कुछ भी रहेगा, एनी टाइम जस्ट लेट मी नो.
नहीं, मैं कल संडे को बनाऊंगा सर इसका रिप्रेजेंटेशन, एंड देन आई विल शेयर विद एवरीवन हु इज कंसर्न्ड.
बट अर्पित, मुझे जो लगता है ना, वी शुड गो थ्रू द लोकल बेंचेस ओनली. जैसे सूरत में हो गया, रायपुर, कोलकाता, ऑल द बेंचेस वी फर्स्ट सबमिट इट टू द लोकल बेंच एंड देन
Ruchi, we can always share the CC to them. They can forward it.
Yeah. That is the best thing.
Correct.
It should come within their knowledge also.
क्योंकि अभी तो मैं तो ये बोल रहा हूँ कि क्वेश्चन ऑफ लॉ का मैं तो पूरी चीज.
But in between all this, I want to share one good information, a happy announcement that our GST Bar Association has got a room in Kolkata GSTAT.
नहीं, we also have got the room at Jodhpur.
Finally, we got a room. Yeah, so I think that is one good thing. So
we are also getting it today. Today it is going to be like opening है, and we have got a bar room. तो कल उसमें टीवी भी लगा दिया है, सब कब्जा कर लिया हम लोगों ने.
और अविनाश जी, आपने जो बताया ना, वो एक्चुअली हो रहा था. मतलब तो व्हाट वी आर ट्राइंग टू टेल द मेंबर्स इज दैट, जैसे एक एग्जांपल देते हैं, कैंसलेशन ऑफ डीलर्स, रेट्रोस्पेक्टिव कैंसलेशन ऑफ द आरटीपी. रेट्रोस्पेक्टिव आरटीपी का कैंसलेशन का मैटर है सिमिलर टू दैट मैटर. सो वी आर ट्राइंग टू डिस्टिंग्विश कि नहीं, मेरा वाला डिफरेंट इसलिए है कि मेरा इंस्पेक्शन ऐसा हुआ है वो. तो दैट इज व्हाट वी आर ट्राइंग टू टेल द मेंबर्स. आई थिंक दैट इज शुड बी आवर एफर्ट इन एवरी बेंच, बिकॉज़ all the benches are trying to now we'll try to understand what the other benches are giving, क्या order आ रहा है, नहीं आ रहा है. So all those things are there.
अविनाश जी ने जैसा बोला है और बाकी सब सबकी रिस्पेक्टिव एसोसिएशंस हैं. Let's try to make an effort because ultimately it will go to the root of the working of the tribunal. The question of law matter now it is going beyond everyone's reach.
अर्पित जी, खाली एक चीज और शेयर करता हूँ. ये रे ऑफ होप व्हिच हैज बीन गिवन बाय सूरत ट्राइब्यूनल मेंबर्स. दे आर सेइंग कि भाई हम आउटराइटली वी आर नॉट गोइंग टू रिजेक्ट द अपील्स ऑन द लिमिटेशन. वी विल कंसीडर द फैक्ट्स. इफ द सर्विस वाज देयर, प्रॉपर सर्विस वाज देयर और नॉट देयर. इफ यू आर एबल टू डेमोंस्ट्रेट कि वो नहीं था और आपको नहीं पता था, देन वी विल गिव यू रिलीफ. दिस इज orally what they have said that we are not going to reject merely on the basis कि 120 दिन हो गया. So let's see.
Date of communication. Date of communication.
Date of communication. What they are trying to focus. If that happens, then I think many people will get the relief.
Yes sir, because high courts में भी ऐसे orders आए हैं कम्युनिकेशन के बीच में पोर्टल में additional notices में additional orders में आ रहे थे तो ट्राइब्यूनल को कंसिडर करना चाहिए. एंड सेकेंडली आई एम फाइंडिंग दैट कि ट्राइब्यूनल एस्टेब्लिश 9 साल बाद हुआ है और उनको 9 महीने में सारे डिस्पोजल करने हैं. इट कैन नॉट बी डन ना, टाइम लगेगा. आप सिस्टेट देखिए 2011 12 13 के मैटर्स चल रहे हैं अभी. तो दोनों तरफ से उनको देखना पड़ेगा, हड़बड़ी करके नहीं. वो फटाफट जो है सारे बेंच प्रिंसिपल बेंच में सारे एक इकट्ठा कर लिया और एक पॉइंट में डिसाइड कर लिया. बिकॉज एवरी केस हैज एन इंडिविजुअल फैक्ट्स व्हिच हैज टू बी सीन. और एक कम्युनिकेशन का तो इतना बड़ा प्रॉब्लम है जो इतने सालों से चल रहा है. वी हैव रिप्रेजेंट नंबर ऑफ टाइम्स कि सर आप जो है हियरिंग में एआर को कमिश्नर अपील्स हो गए, एससीएन हो गया, they have added the portal in the system of authorized representative or authorized person who is dealing with the matter, but they are not communicating anything in SCN level also, in appeal level also.
Correct.
वो भी एक बहुत बड़ा लैक्यूना है जो अभी ट्राइब्यूनल कम्युनिकेट कर रहा है यार को. भले सब केसेस में नहीं हो रहा, आरूप सर ने बोला थोड़े केसेस में हो रहा है, but they are communicating. But in GST as a whole there is no such mechanism that they are communicating us.
Correct. अच्छा, एक और इशू है आरपीजी. आई डोंट नो वेदर यू हैव काउंटेड दैट और नॉट. अरूप जी आप भी, कि एक्चुअली मेरे को मेनी लाइक appeals are being filed by the department, and in all those appeals couple of people have approached me. Like yesterday I was approached from someone from Dehradun. So where is the like place to file the wakalatnama in that case? It's not there.
No, so what we are doing, we have to say एक बार mail आ रहा है, then you have to register. Because without registering you can't file the CO.
Correct.
Cross objection register कर रहे हैं, CO file कर रहे हैं. जब CO file कर रहे हैं, there you have the place for uploading additional documents.
That is not correct. Because if someone don't want to file a CO, it's pure factual matter.
फाइल कर सकते हो. नहीं अब रजिस्टर करके आप फाइल कर सकते हो. Like many people are not filing the CO. तो क्या कर रहे हैं, रजिस्टर करके वो आपको
नहीं, it's not because yesterday what we did, we tried to register that client.
Yes.
Got the documents downloaded, then we tried to file wakalat. We made a phone call also to the help desk. They said कि नहीं अभी ऐसी कोई फैसिलिटी नहीं है सर, आप जब रिप्लाई फाइल करोगे तो ही आपका वकालत जाएगा, अदरवाइज नहीं जाएगा.
अच्छा, that could be tagged because in our cases we have filed the CO and then filed the wakalatnama.
So CO,
आप बोलो कि without CO.
Correct. There has to be a place that like if it is being reflected in my login or in the login of the client, then client can upload the wakalatnama, no?
हाँ, अपने क्लाइंट के लॉगिन में आएगा तो अच्छा क्लाइंट ने आपको यार कर दिया अटैच. बिकॉज क्लाइंट ने आपको AR के हिसाब से अटैच कर दिया ना.
नहीं, सी AR की तरफ से अटैच करने के लिए भी उसको रिप्लाई में ही करना पड़ेगा,
फाइल करना पड़ेगा.
तो अभी now if he is not filing reply, they want time to file reply, but they want me to appear on day one. There is no facility.
But I'll speak to one of my team members who's handling the
please. So if there is any solution, please let me know because we are finding it difficult.
हम लोगों के केस में क्या हो गया, हम लोगों ने CO फाइल करके then we have tagged the AR and we've done that.
Then it is there. Then it is there.
आप बोल रहे हो कि अगर फायदा नहीं हुआ.
क्योंकि अगर आप रिप्लाई या CO करते हैं ना तो डिपार्टमेंट कर रहे हैं. There are 5-6 tabs.
अविनाश जी, फिर हम लोग वो कर सकते हैं जो डिपार्टमेंट कर रहे हैं. एक पेज का CO फाइल कर रहे हैं वो लोग. We can find the first one page, see, file everything, go for the hearing and say, give me 30 days time for filing additional CO. So because department is doing that, they are filing one page CO and then going and saying, give us 30 days time.
Hey, Arupji, whether this 30 days or 45 days are to be given by the bench or it is coming from the rule, because the rule or the section does not say that the bench has to give. It is my statutory right.
Time चला गया उसके बाद.
But time, again, this was discussed yesterday with the AR, that from when the time would be started. So what he said that the time should be started by when the appeal has been admitted.
But there is no process of admission of appeal in GST.
No, the assistant registrar would be doing the admission as per rule 25, if I'm correct. They have to admit the appeal and give a number. It is
correct.
not.
File a number. Yes.
See,
But
there
practically
is a
appeal
difference between an appeal being received and appeal being admitted. And between that, there is a scrutiny and the defect part, which is taken. So once it is admitted, then only then there is a provision of endorsement of copies to the respondent. So if the copies are not being endorsed, how would I be filing the reply of the cross objection? Yesterday we raised this issue with the registrar here at Jodhpur bench. Sir, unless until you are admitting and you are providing as the copy as the endorsement of copy to the respondent, our time limit of 30 days and 45 days should not start. And he also admitted. Then we asked it how those would be communicated, whether all those documents would be received through mail once the appeal is admitted, or I would have to log in on the GSTAT portal, then I would be able to access. So how that would be communicated? Because this date of communication to the respondent is very important from the point of 30 days and 45 days. And we specifically said that we should not be asked to go before the bench and ask for 30 days and 45 days. It is my statutory right which is coming and it should be given. And any appeal which is being fixed after admission, it should be after 30 days or 45 days only.
अर्पित जी प्रैक्टिकली क्या हो रहा है, द डे वी गेट द मेल ना, उस दिन से काउंट चालू कर रहे हैं वो लोग. जिस दिन आपको पता चला कि आपके अगेंस्ट एक अपील फाइल हुआ है, क्योंकि आपको तो पता नहीं चलेगा अगर आप रजिस्टर्ड
नहीं, पर वो अपील अगर डिफेक्टिव होगी तो 30 दिन में करूंगा क्या?
डिफेक्टिव नहीं, एडमिशन के बाद, एडमिशन हो गया उसके बाद रजिस्ट्रार हमें मेल भेज रहे हैं कि आपके अगेंस्ट में एक ऐसा अपील फाइल हुआ है, काइंडली गो टू द पोर्टल एंड चेक. तब जाके हम लोग रजिस्टर, और उससे अब डेट चालू हो रहा है. और डिपार्टमेंट को भी सेम चीज है, डिपार्टमेंट को मेल मिल रहा है, बट डिपार्टमेंट को एडिशनल टाइम मिल रहा है बिकॉज डिपार्टमेंट इज प्रैक्टिकली फेसिंग ए चैलेंज रिगार्डिंग टैगिंग. जैसे आपने तो कमिश्नर ऑफ स्टेट सर को आपने बना दिया रिस्पॉन्डेंट, बट अभी कमिश्नर ऑफ स्टेट सर ही हैज टू गिव इट टू द प्रॉपर ऑफिसर फॉर गिविंग दैट रिप्लाई टू द क्रॉस ऑब्जेक्शन. तो उसमें टाइम लग रहा है, तो इसलिए डिपार्टमेंट को 30 डेज नहीं, वो तो 90 डेज में मिल रहा है, वो अलग बात है.
डिपार्टमेंट के लिए तो सब जनरल रहते हैं.
तो
एसएससी के भी तो चैलेंज, बेचारे को कम्युनिकेट ही नहीं होता, ईमेल ही नहीं मिलता.
But sir, we face the issue regarding this cross objection also. That sir, I'm Nitin Bansal. I also face the same issue. The date of admission of the appeal filed by the department was 11th of June, and then on the date of admission, the hearing was provided, and the bench instructed us to file the cross objection within 15 days. They asked all the persons who were aggrieved in this issue, all the appeal filed by the department, and they asked collectively all the authorized representatives that how much days you need to file the cross objection. And already all mentioned that we need 30 days or 45 days. No, we are giving you 15 days only. File it till 25th of June. And then again on 2nd of, I'm talking about Kolkata bench only, sir. And on then 2nd of July, we got the hearing. And again, the bench asked why the cross objection has not been filed. And we mentioned that we need some more time because in statutory provision, we have this 45 days. And according to the act, we have this 45 days time from the date of admission. So he agreed and he told, okay, we are giving the next hearing on 23rd, and you file your appeal, file your cross objection before that. And second thing, sir, one more issue, peculiar issue we faced on 23rd of July, and I had a conversation with Arubda also before my hearing in Kolkata bench. What happened that we were having this online appeal, and simultaneously the physical appeal was also going on. Physical hearing was also going on. And in the second case,
paper book ka issue
na? Sir, paper book issue. The bench in the second, you must have seen that. In the second case also, only the NBT case, the second case, the bench scolded that authorized representative that why haven't you brought the physical copy of the whatever circular you are referring or whatever case law you are referring, why haven't you brought the physical copy of that? Then he mentioned that sir, there is no, we asked the assistant registrar, we were not needed to submit the physical copy. No, you need to bring the physical copy of the circular or this case law. How will we download then? How we will see? And I was facing the online hearing. Then again, when my 10 came, then I said I can mail the document, but I have uploaded all the documents. Then the bench mentioned that we have seen that you have uploaded all the documents, but our system is not working, so we can't download the documents and we can't see that. You need to mail or physical deposit all the document before the hearing.
So Nitin, that is a temporary development. We spoke yesterday also. So that is a temporary development. I will give you the background. क्या problem हो रहा है? Problem ये है कि जो system जो उनके सामने है, उसमें document नहीं खुल रहा है. तो इसके लिए पूरा जैसे आप जो हियरिंग के बारे में बता रहे हो, रिफंड का हियरिंग था, तो डिपार्टमेंट
Yes,
हैज
sir.
गॉन इन अगेंस्ट रिफंड। तो उसमें क्या है, रिफंड में देयर आर मेनी डॉक्यूमेंट्स जो एनेक्चर्स वगैरह इन्होंने दिया है, इसके बेसिस पे रिफंड मिला था, तो बेंच मेंबर्स के सामने वो नहीं खुल रहे, तो इसलिए उन्होंने बताया कि इसका आप फिजिकल कॉपी क्यों नहीं दे रहे हो, तो हमारे जल्दी हो जाएगा। फिर उसके बाद से ये बस एक प्रेसिडेंट, कल भी जब हम लोग हियरिंग में गए तो हमको बताया गया कि फिजिकल पेपर बुक दीजिए, but again it is clarified that this is not as per the rules, and also honorable president was quite vocal on this, that everything digital, nothing will be physical. So what we are told that this is a temporary measure जब तक system आपका NIC का जो system provide किया, that is not running properly, because ideally what should have happened is, like it was happening, is that they will go on the, you have seen the system in front of them, no, in front of the bench members, दो system,
Yes,
एक
sir.
उनके सामने है और दूसरा उनका वीडियो है राइट हैंड साइड पे, आपका वीडियो जहाँ पे दिख रहा है, तो उनके सामने जो सिस्टम है उसमें उनको एक्चुअली ऑर्डर दिखना चाहिए, एनेक्स्टर दिखना चाहिए। व्हाट इज हैपनिंग इज व्हेन दे आर क्लिकिंग विद द स्टाइलस, उसमें एक एक एनेक्स्टर खोलने में 10-12 मिनट लग जा रहा है। द एंटायर हियरिंग इज गोइंग फॉर अ टॉस, दैट इज वन थिंग, एंड अनदर थिंग इज अबाउट द सर्कुलर्स एंड case laws. What is happening, some people are giving in the plain version say only one page of the case law जहाँ पे वो relevant para है, या फिर सर्कुलर उन्होंने कोई रेफरेंस नहीं दिया कहाँ से लिया है, तो दैट्स व्हाई दे आर सेइंग कि फॉर द फिजिकल कॉपीज, बट yeah, so but this is a development for Calcutta bench that they have asked for paper book from yesterday also they have asked, and this will be there for some time till the system glitch is properly settled, I think. Now we have
But
to
sir,
see what other benches are
how
also
this is
facing.
possible when the SSC or the authorized representative is located in some remote area, suppose Siliguri is located, then how he will come to submit the physical copy and all? That is the problem before the hearing, and this is the
Yes.
thing that
नहीं, that we already addressed yesterday. That we already addressed कि सर हम तो यहाँ से अटेंड कर लेंगे। अभी सोचिए कोई गुवाहाटी से अपीयर कर रहे हैं, कोई राजस्थान से अपीयर कर रहे हैं, so it will not be physically possible to, maybe say I'm known to you, maybe you send to my office, I'll get it submitted, right? But not
uh,
everybody will take this. Why should they take this pain when the system is there that it has to be digital? But I think, but again, कल
Arunji,
yesterday, नहीं,
if
but
we go
अभी जी, I
through,
just नहीं,
हाँ,
एक चीज जरूर बताता हूँ, बट कल
हाँ,
2-3 हियरिंग हुआ वर्चुअली, जहाँ पे कि देवर टेकिंग द हियरिंग फ्रॉम आउटसाइड कोलकाता, तो उसमें लेकिन फिर से उन्होंने वो डिजिटल पे सारा सुना है, फिजिकल कॉपी नहीं मांगा है। तो आई थिंक इट ऑन केस टू केस बेसिस, जहाँ पे है वॉल्यूमिनस डॉक्यूमेंट्स है तो वहाँ पे इशू हो जाएगा। हाँ अर्पित जी,
we had communication with the assistant registrar also. Then he told that you can mail us the copy of the documents. So I
yes,
told him that you will face the same issue only when I will mail you the documents, and again you will have the same issue that it is not being downloaded or we are having the technical glitch. So no, he allowed that in the case of online hearing, we have asked the bench, and they are saying that you can mail the documents, additional documents.
basically they want to open the documents faster, that's it.
Regarding cross objection, I have to add only one thing, that cross objection is not essential in every appeal. Cross objection is not our submissions. So if bench is saying you file it within 45 days, something, the cross objection is something separate. We may choose to file or not choose to file. If in the order I don't have any grievance, I don't have any other points for appeal, then cross objection is not required to be filed. Okay.
मतलब
So
आप एडमिट कर ले रहे हो उस अपील को जो डिपार्टमेंट ने फाइल किया है।
it is not that, sir. Cross objection is a concept, something different, sir. Cross objection is a person that supposing an order has been passed in favor of in my favor. Okay. Department has gone in for appeal. Okay.
Yes.
No. In that order, if certain favorable point of mine were not considered, okay, then I can file cross objection with regard to those points. That is the concept of cross objection. Or if there were 3 issues, 2 were settled in my favor, 1 was against me, and in that case, those 2 issues, the department has gone in appeal, so I have got also a chance for the 3rd issue to be raised against the department.
Yes.
So this is cross objection, sir. The cross objection is not essential for every appeal. We just file the replies, submissions, our submissions. That was my point, sir. If anything is different, then
Manodar, the only thing is that what you are saying is also there in rules. But that's why they had given two different timelines: 30 days for filing of reply and 45 days for filing of cross objection. So if you do not want to raise any fresh ground, only we are required to file a reply on a point-to-point basis. That is, we have got 30 days. And if we want a new ground to be taken, which has not been taken, or issue to be taken, which was not appealed by us, then we can file a cross objection.
Very nice, very nice. No, sir. My point is that if I have not filed my reply within 30 days, supposing I file at the time of hearing, is there any harm? Is there any bar for me that I can't put the things at the time of the hearing, sir? That is my point basically. Because then, sir, if 30 days deadline is to be seen, then everybody has to file it within 30 days. Then we have to prepare everything within that 30 days, no, sir. So like in CSTAT or in ITAT, whenever we appear, we can file our submissions at the time of hearing also, or 2 days, 3 days before the hearing also, sir. Kindly.
Sir, that's why I am saying that this tribunal is working like a Supreme Court. They are not working like a tribunal.
And sir, the members are novice basically. They are all novice members. They don't know the GST law basically. They are from some traffic tribunal, some other tribunal. It's like that, sir. And sir, my last point is that condonation of delay. They are saying that condonation of delay, all the matters will go to principal bench. Okay, that what I have heard. But sir, in the cases I have, our members have rightly said earlier also that there are a certain points of that. What is the date of communication? We are disputing that. So that is not within the condonation. That is not within the ambit of condonation of delay. So those matters should not be go to principal bench. That is my fear, sir.
So that is the issue. The bench is having a knowledge problem. I think that they are having this experience problem, because in the hearing we saw that in the case of inverted duty structure also, the authorized representative was trying to convince that there is no bar in the law regarding trading or manufacturing, and repeatedly the bench was enforcing no, the something hasn't come into existence. Something has to be manufactured, then only inverted duty structure refund will be allowed. They were mixing this excise and GST. They were confusing between that there is no trading requirement or something. And they were like,
basically,
how can you?
Basically, they should have a class of 20 to 25 days of the settled issues which have been settled by the High Courts, and wherein the department not gone into the subsequent appeal before the Supreme Court. Because if they would not be following that, then they would be going against settled jurisprudence where even the department has not challenged it before the Supreme Court.
No, there we need to bring it before them.
But Nitinji, what Nitinji is saying that he tried to bring, but they were not understanding it.
I didn't try to bring my hearing.
नहीं नितिन, जिसमें क्या वो इशू बोल रहे थे ना कि वो जो HSN सेम होने से आपको इन्वर्टेड स्ट्रक्चर नहीं मिलेगा, वो उठा रहे थे क्या?
हाँ sir, same issue I'm telling that, but the bench was having the perception that how can you claim the refund when there is when something hasn't come into something new hasn't come into existence. You haven't manufactured anything. So they were having this confusion, and the authorized representative was trying to convince, though he was not able to convince the bench that there is no need of this manufacturing or something in the GST for claiming of inverted duty structure. But the bench had that perception that department is right because something hasn't come new into existence. So the inverted duty structure refund should be disallowed. And they were having this manufacturing concept in their mind, that excise concept, that there should be something new in the existence. You can't claim just you are mixing the packing material. You can't claim the inverted duty structure refund. There should be something manufactured.
Oh, Malhotra ji said that the judicial member is a traffic tribunal judge and the technical member is a hardcore departmental person who...
Sir, one more thing, sir. They have got the other members which were in central size earlier. They are members and they have the concept of central size only.
But that's all.
That is the point. And sir, one more thing, in Jammu, they were saying that all the pre-bite has to be made in cash. Then I raised this issue in our group also. So this is their level of knowledge. So I think we will have to make them understand, like we have made the state tax officers understand the law. We will have to make them understand the law.
Even when the bench came to our place for when they came before 30th of June for encouraging the filing of the appeals, and I was having the query, I asked them that what you're taking as a date of date of filing of the cross objection, whether it should be calculated from the date of admission or whether it should be calculated from the date when the department filed the appeal. The bench was very clueless. They were not knowing that what I am talking about, and ultimately they referred the question to the assistant registrar. Then assistant registrar answered the question that no, from the date of admission you need to count the days from the 45 days, and the bench was just clueless about the things.
चलिए रूप जी, it's 10 o'clock.
It will take time to settle. अच्छा 10 बज गई है क्या? अरे
हाँ.
अरुण जी गौरव here, just I'll take half a minute. ये जो अपील नंबर का अलॉटमेंट शुरू हो गया है सर. I got couple of communication done to the dealer also and to me also.
Okay.
और वो स्टेटस जाके देख रहे हैं तो इट इज कंप्लीटेड एंड देन अभी हियरिंग डेट नहीं आई है बट अदरवाइज नंबर गिरना शुरू हो गए.
चले आ जाएगा तो हियरिंग भी आ जाएगा.
हाँ.
So exciting times ahead, especially for people like now. Before we used to juggle between the department and High Court, and maybe our offices. Now we have to juggle between department, tribunal, and High Courts, and multiple other forums also. So I think it will be exciting times ahead, as they say. So I think Arpit ji,
Arupda, as far as ये juggling, Arupda, जब तक ये juggling स्क्रीन के बीच में ठीक है, अदरवाइज स्टेट टू स्टेट हुआ तो हालत खराब हो जाएगी सर.
तो ठीक है ना, आपको देखने को मिलेगा ना. जैसे अभी मैं एक दूसरे स्टेट में गया था,
मेरे
लोकल साइट सीइंग भी करके आ गया.
मेरा 6 स्टेट में लगा हुआ है सर, मैं ऑलरेडी घूम रहा हूँ.
ओके, सो आनंद जी, आज आप वोट ऑफ थैंक्स बोल दीजिए. आज आप हो क्या? I don't know whether I think Anand ji.
Nitin ji, I am there.
अच्छा, Anand ji there. Yeah.
Nitin ji.
Over to you for vote of thanks.
Yeah, thank you everyone for joining this morning. Basically, Arupda, Arpit ji, specifically Poddar sir, all of for share their knowledge and share their happening to the GSTAT level at every local benches, and various benches are starting now, and we are representing, our members are representing for various issues. So this interaction was quite interesting and useful for all of us. Good suggestions from Arpit ji for filing of representation for happening. Certain things are happening at principal bench level, which should not happen. Poddar sir also suggested for the same. And really, this is very helpful, really knowledgeable and enriching everyone. Thank you all for joining, and see you for next SMS as well.
Thank you, everyone.
Thank you, Anand ji.
Thank you, Anand ji.
Thank you. Arpit ji, any final word? Yes.
नहीं, फाइनल वर्ड तो बस वो प्रिंसिपल बेंच वाला मैं तैयार करके भेजता हूँ, तो सब भेजो इसको यार, और कुछ नहीं है. थोड़ा हिलाना पड़ेगा उनको.
और एक चीज है कि नेक्स्ट वीक गोइंग बैक टू द बेसिक.
हाँ,
from next week we are going back to the basics. We'll again start discussion on sections. So if anybody wants to volunteer, please volunteer the discussion again. And some of the members, they tell me कि faculty group में session लेने में डर लगता है, क्योंकि everybody is, I'm telling you, all of us are learning and all of us are students of GST. हम रोज नया कुछ सीखते हैं, तो आप जैसे भी session लोगे, it will be value creating for all of us. I'm sure that everybody is going to create value for all the faculty members who are joining the session. So don't be afraid, what is going to happen about the discussion. It will be a wonderful discussion, I'm sure. Thank you very much and have a wonderful weekend.
Yes. Only one thing I just want to ask. There is a working group formed for the centralized administration. Yeah, one thing is that there is a group for centralized administration. Working group is formed for centralized administration of taxpayers. This office memorandum has come.
Yes.
Fortunately, our commissioner, Mr. Pradeep Gurumurthy, is from Aurangabad. He asked us to submit whatever the issues you have and whatever the suggestions for the centralized administration, whatever the issue. So he is a part of that committee, part of that group. So our suggestion will directly reach to that group. If anyone is having, kindly you can go put on the group, or can you DM directly to me? Anything possible.
Okay, that's wonderful. Yes. That's wonderful. We also put in the group also. So I think all the members will be aware there. Okay. Thank you.
Thank you.
Good day. Bye-bye.
Bye.